financial advisors have morphed over the years, and some of us have morphed more than others into doing more for the client because that's what's really needed instead of just trading stocks and bonds or managing portfolios. And a big part of that, there's several areas. There's taxation, there's insurance issues, but one of the big ones is estate planning.
The baby boomers, richest generation by far that's ever lived.
Yeah.
I mean, not even, there's not a close second,
No, it's not.
right? I mean, the wealthiest generation, more assets to pass on. In most cases, are probably not going to be spending the vast majority of their money, of their wealth. So a lot of that's going to be transferring. And we hear so much in our industry about the great wealth transfer that's already happening, that's going to happen over the next couple of decades. I think some of that gets a little bit overblown, but the idea is very much, hey, baby boomers at some point are going to pass away with all this money in transit. And it's going to be a problem for the people that are inheriting it, potentially, if there's no plan in place. Thanks for joining us for this edition of the Retirement Planning Happy Hour. This is Eric Douglas, Chris Vaughn, Family Wealth Planning Partners, headquartered in beautiful Louisville, Kentucky. Maybe not so beautiful today.
Not quite as beautiful. But
not as beautiful as it was maybe.
It's not pouring down rain, and it's not cold.
Well, it's a little chillier.
It's not cold. It's not warm either.
I got spoiled in April. April was really
did.
nice, and
it was
now
in the
May
80s in April.
Yeah, and now May has not been as nice, and I'm not happy about it. So. Anywho, all that to say, pretty cool topic. Well, I don't know if it's a cool topic.
I think it's a cool topic, but I think that comes down to what we'd like to get into.
Yes, no, I do like talking about it. I do talk about this a lot with clients, but estate planning is what we're going to talk about today. It isn't necessarily the most fun topic to talk about because we're talking about folks, passing away, and unfortunately that does happen sometimes with people. It's
not sometimes; it's really more of an all the time. But
we all end up there one day, right?
So we will all deal with it, right?
Maybe not always the most fun topic, but very much a necessary topic for us to talk about as we work through a portfolio and financial plan for clients. Because if we do our jobs right, there will absolutely be an estate plan that we have to plan for if we're doing our jobs right, which hopefully we pretty much always are, right? So with that being said, that's going to be the topic for today. You brought a pretty interesting little bottle here.
I brought something different this time. This is the Old Forester 117 series. Now, I think, in fact, I'm sure that we've done a 117 series before, but these are all different.
We did, yeah.
Right? They have 2, sometimes 3 releases a year. I don't remember what the exact rules are on this. So Old Forester is, Brown and Foreman. This is one of the old guard in the bourbon world. I am a huge Old Forester fan. I don't remember the last time I had an Old Forester, or as some of us call it, Olfo, that I didn't like. I mean, it's all outstanding.
Yeah.
The 117 series name comes from, that's where they're located, downtown Louisville on Main Street is 117. This particular one, this is the December 2025 release, and it is called Prohibition Era Still Proof. So I will read what it says on here very quickly. During Prohibition, Old Forester and 5 other Kentucky distillers were issued permits to bottle existing whiskey stocks as medicine. Wink, wink, hint, hint, right? Anyway, in 1930, the federal government granted these distillers a 100-day window to replenish their declining stocks. During this historic period, Old Forester was distilled at 130 proof.
We got to, burn
this
back,
one's screaming, right?
If you're going to kill bacteria, then,
Well, it's medicinal, right?
Absolutely.
Now, I have not tasted this. We opened this bottle up as we were getting ready for today. I will tell you that the 117, I've had many of these. Most of them are pretty good. Some of them are outstanding. The one that they did that was the extra old, that was the 1910 that they extra aged, it was their version of a double-double. Yeah. Was just one of the best bourbons I've ever tasted. I've also had a couple of these that it's like, well, that was expensive for the taste, right? So I don't know what we're going to get here. I'm pretty sure this is based on their 1920, which was also a prohibition thing. So we'll see what's going to happen. No promises.
The nose has some kick to it.
Right.
I'll give it that.
Yeah.
We'll save the tasty notes for the
when
end.
it burns before you taste it, you know what's coming, right?
So no, it's all right. So estate planning. I know that you talk about this a lot in workshops, and you kind of go through the levels of estate planning, and typically we have kind of 3 levels. I don't know how much in detail we want to get around each one, but I think I'll start off talking about the importance of estate planning.
Yeah, absolutely.
Relative to today, because you were looking at some stats, and there we had a little bit of a brief conversation beforehand talking about the number of baby boomers that are out there. And the oldest baby boomer, well, every stat you look at, the baby boomers are by far and away the richest generation that has ever lived, right? That was a fantastic face, by the way. That
wow.
You just
Okay, I have no poker face whatsoever if you're watching this.
I don't know if I've ever seen you make that face while we're recording here.
We'll talk about what that one was later.
Well, I might figure out here in the second when I'm done yapping. But the baby boomers, richest generation by far that's ever lived.
Yeah.
I mean, not even there's not a close second,
No, it's not.
right? I mean, the wealthiest generation, more assets to pass on. In most cases, are probably not going to be spending the vast majority of their money, of their wealth. So a lot of that's going to be transferring. And we hear so much in our industry about the great wealth transfer that's already happening, that's going to happen over the next couple of decades. I think some of that gets a little bit overblown, but the idea is very much, hey, baby boomers at some point are going to pass away with all this money in transit. And it's going to be a problem for the people that are inheriting it, potentially, if there's no plan in place, right? And so, especially as we were working with, a certain level of clientele, we have kids all over the place, and different kids and different relationships in different states, right? Putting together a comprehensive estate plan as a part of an overall financial plan becomes very, very integral to the success of that plan, right? Because the plan doesn't end when you pass away. The money,
no, that's absolutely true.
The money is still there. The money still goes to someone. The money will get spent. It's going to do something. It just becomes, someone else's at that point, and it's in transit at that point. But it's still there. We still have to plan for it. And that becomes a huge, huge piece of the overall financial puzzle that needs to be managed and prepared for, because if you are not properly putting together a good estate plan, then one, that's going to cost your kids a lot of money.
Yes,
potentially
absolutely.
with probate and lawyers and all that stuff, and then potentially in taxes as well. A lot of extra money potentially going to the IRS that we don't want to have to pay, and even more so than that, just not even from a dollars and cents perspective, just from a headache perspective,
peace of mind,
and headache perspective. I mean, it's not so many times we talk to folks that have inherited assets, and they have war stories about dealing with their parents' estates, about their grandparents' estates. It's not so much about, I miss my parents so much. It's, oh my God, settling their estate was an absolute pain in the butt. It was a nightmare.
Or siblings or other family members who used to get along okay.
Yep, we see.
And they ain't friends no more because dealing with that estate, arguing about who gets what, it can be a genuine nightmare for some families.
Or even more so, plans that are not in place, even as the parents are still alive.
Yeah.
But maybe the parents have become incapacitated, or they're older and they're not really in a great position to be able to do anything at that point. And you have kids arguing about what they're going to do or how things need to be structured while the parents are still alive, knowing that there's not a proper estate plan that's in place, and the proper documents and the proper powers of attorney and all that other good stuff hasn't been taken care of, even if they're not even passed away yet, right? So all of these things to say, an estate plan, especially with the absolute wealthiest generation that has ever lived, currently in the process of beginning to pass away. I don't know a better way to phrase that, right? But, baby boomers, all that money is going to pass on to someone. And so estate planning becomes very, very, very important part of our conversations with clients. So with that, I'll put the ball in your court.
Okay.
And let you go through kind of how you explain and walk through that process with clients.
Okay, so when I'm sitting down talking with clients about, the importance of an estate plan, to your point, when we're talking about true, and we hate this word, holistic financial planning.
I hate that term.
I hate it, but it's kind of the word that most people use for it. This is where, and we talked about this in our last episode, where financial advisors have morphed over the years, and well, some of us have morphed more than others into doing more for the client because that's what's really needed instead of just trading stocks and bonds or managing portfolios. And a big part of that, there's several areas. There's taxation, there's insurance issues, but one of the big ones is estate planning. I don't know who originally came up with this. It was not my idea, but it was something that I've learned over the years, that there are 3 different levels of estate planning. And it kind of organizes your thoughts in a way that the average person can truly wrap their heads around this. So when I'm talking to clients about developing an estate plan, I explain to them the 3 different levels because then I can recommend one and they'll know why. So it's basically, when you pass away, and there's parts of an estate plan that are in force while you're still living, especially when we start talking about powers of attorney. So not all of this applies to just when you die. But the 3 different levels are based upon what is important to you, right? So level 1 is really all it does is make sure that what you own ends up where you wanted it to. Right? This thing was important to me and it's going to end up with my nephew, with my eldest son, with my 2 girls. They're going to split this one 50-50, whatever. Whatever your assets are, when you're gone, there is no question about who gets it, period. Right? Level 2, we start getting into control. It's important to me that these things happen the way that I want them to happen when I'm no longer here. Okay, that's level 2. And then level 3 is where we get into everything from level 2. So it's control, but it's also protection. And level 3 is when people really start, their dander gets up a little bit. So let's just walk through them one at a time, what they are.
Sure.
Right? So when we talk about the assets that you have, remember, to your point, Eric, if we do our job, or people like us do our jobs properly, it doesn't really matter how long somebody lives. There will be assets left over when they're gone. Okay. So who gets those assets? What's important to you? One thing that I don't like to hear is, oh, I'm leaving everything to my kids. I'm not saying that's a bad thing, but that's a not well thought out thing. I'm leaving everything behind to my kids. Well, but who gets what? How did they get it? I don't care. I've heard that one more times. I don't care.
I've heard that one too, yes.
I'll be dead. I don't care. Okay, well, let me see if I can modify your thought a little bit.
I've heard let them fight about it.
Yes, I have never heard those words, but the same type of thing. You know what? I'm not leaving anything behind. I'm going to have the last check bounce. Okay. Then you need to work with a different planner than me because that's not my job, right? We've all heard all kinds of stuff. Okay. I think in most people's cases, it's simply a matter of when I'm gone, here's who gets what in order to make sure that your wishes actually get done and to make sure that there's no infighting. The worst thing in the world is the death of a parent to cause siblings or excuse me, not siblings, but children or grandchildren to no longer be friends with each other. That sounds like a genuine nightmare, and we've seen it. And I don't have the stat handy, but it is a majority of the population that has never done level 1, which all really level 1 is, it's a will. It's just a document that states, here's who gets what when I'm gone. The house goes to my 2 kids, and they can share it, they can sell it, and split the proceeds. That's the most common. Or, one of them can keep it, but they have to pay the other one their share. There's a million ways to do it, but that's who gets the house. And this is where you can get into bequests. It's very important to me that the silver spoons or whatever it is that you collected, that's, I want this person to inherit that. That's called a bequest. You can all of that can be done with a will. If you fail to do a will, That is what's called dying intestate. And we've done many a workshop where we're talking about this, where we start the workshop off with a list of famous people. And it's a long list of people that everybody has heard of, that we're all fairly confident they had a lot of money. But they died without a will. They died intestate. And some of those are still not settled. It's 2026. Michael Jackson's estate is still not settled because he died intestate. Mm-hmm. That one may not be settled in the next 15 years. Who knows? Because people fight over this stuff. It's stunning to me, the number of people that actually have assets, that are moderately wealthy, that do not have even the simplest estate plan, which is basically a will.
It took James Brown a while just to get in the ground.
Yeah.
Because his estate was still being battled out. He hadn't planned. Prince was another one.
I don't think that one's settled yet. And Prince was worth a boatload of money, I would suspect.
Especially with those guys, because a lot of their wealth is tied up in their
intellectual
property, their intellectual
property,
their catalog, right? And so he still owned his catalog.
Yeah.
And so the who gets the rights to that catalog and who gets to profit
you can see why in that case why people would fight over it, because that could be worth tens, if not hundreds of millions of dollars in the short term.
Yeah, because every time I listen to a Prince song on Amazon Music, somebody's getting paid a couple cents.
We were literally at a networking meeting that I was at just this morning. One of the guys was talking. He said, we started our company in 1999. And 4 or 5 people started singing "Party Like It's 1999" from Prince. If we did that, that stuff's getting played like crazy. So, all right, take that and wind that down to somebody who doesn't necessarily have the tens or hundreds of millions of dollars. Wealth is a relative thing to a lot of people. I mean, I know you've had people come in and say they 100% believe that they are rolling in money, and they've got less than $100,000. Well, if they have that belief and then money is left over to their kids who probably have a similar belief, we've talked about how we learn about money when we're young, you can see how siblings would end up fighting. So you can say, well, I don't have that much, they won't fight over it. I'd say there might be a greater chance if you don't have that much than if you have a lot.
What's amazing, so it's interesting, here's an anecdotal story from yesterday. Okay. This is how often we talk about this stuff. But had a client that she became a client because she and her father passed away. She inherited some money from her dad. It wasn't a tremendous amount of money, but it was, it was a little more than she'd ever had in her life and more than she was ever expecting to have. But she inherited everything that her dad had. It was low 6 figures, but to her, the idea of having that much money versus relative to where she came from was unfathomable.
Yeah.
And what's interesting is the way that her family and other people in her life started treating her when they found out that she received this inheritance, which by all accounts is really, in the grand scheme of things, not that much money.
Right.
I don't want to downplay it, but I mean, it was less than $200,000.
Yeah.
And she started to realize, like, her views on money. We had this conversation where when she first received it, she thought she hit the lottery. Mm-hmm. Now that she's kind of had the money for a while, and we've invested and we've been working with her, and we've talked through some of these things, but she's starting to realize that it's really not, in the grand scheme of things, because she's still actually pretty young. Mm-hmm. Her father died at a relatively young age, and she's realizing that, this really isn't that much money, but she still has people in her life treating her like she's almost a millionaire.
Yeah.
Because it's like, you can afford it. You received all this money from your inheritance. And she's starting to realize it's really not that big of a deal. Yeah. So her views on money are changing because it's all relative to your
wealth
point.
Is a relative thing.
It's all relative. And you don't really realize and appreciate maybe how important it is or how not important it is until you start getting more of it. And you realize, well, really, this isn't that big of a deal. But when you don't have it, it seems like it's the biggest thing in the world.
It's a really big deal when you don't have it. That's true.
So anyway.
So to go on with the level one, the will conversation, some things that people do need to know about. If you have a will, but you don't have the level 2 or the level 3 that we're going to talk about, when you pass away, your estate will be probated. probate really comes across to most people almost like a dirty word. Like we almost say it in hushed tones because anybody who's ever been through probate will probably complain or gripe about it because it's not fun, right? I can't imagine going through probate and thinking, wow, this is a lot of fun, but it's not nearly as bad as what it used to be. In most states, it is a mandatory 6-month period of time from the time you file, and its purpose is to make sure that any debts that the deceased had, those debtors, did I say that word right? Anyway, yes. They have an opportunity to be made whole, to get their money back that you owed them, right? And it could be anything in theory. So probate,
which is why obituaries are in the newspaper.
That's where I was going next. The whole point of probate is it gives people an opportunity to say, he owed me money, I want my money back. So there's a delay period. Like I said, most states it's a 6-month as a minimum. And the other part is it has to be made public. That's where the obituary column originated from, is making people know somebody has died. That's not I want to go to the funeral home, I went to high school with him. No, it's that dude owed me money. That's where it comes from. So that's what a will does. One of the biggest things that I think people really screw up with this, and it is by far the most common type of estate planning, is the level 1, the will, is that when we're discussing assets, accounts, homes, things of that nature, people will say, oh, well, I put that in my will. I couldn't care less what you put in your will when we are discussing beneficiaries on an account. And the reason for that is beneficiaries trump the will. So if you put a beneficiary on, let's just say you're going to put your 3 children on your IRA, right? You put them down as beneficiaries, but in the will you say, I'm going to leave it all to my wife. Your wife does not get that money. It goes to the kids, even though the will actually did say that. And one of our partners has a famous story that we all love to tell, and you know which one I'm talking about. Many, many years ago, he worked in the estate department at a regional bank, and a local physician passed away, married, multiple children, multiple grandchildren. I think there were great-grandchildren in the story, if I remember it correctly. This was a big estate, right? This was a wealthy family. He passed away, and our partner was asked to settle part of the estate, and he was dealing with insurance, right? So he found a life insurance policy that was in force that had a beneficiary name that he didn't immediately recognize. And, that's alarm bells are going off. So he did some checking. Turns out Mr. Physician had been married when he was in medical school. And after he finished medical school, he divorced his wife and he married, I believe it was his nurse, if I remember the story.
It was.
But the point was that while he was married the first time, they took out a $1 million life insurance policy, and that policy was still in force, but he never changed the beneficiary. So even though he might have done wills, trusts, everything, he might have changed the whole smash. I don't know that part of the story. He never changed the beneficiary on that life insurance policy.
And he'd been paying premiums and all that stuff.
Yeah. Okay. So when it happened, our partner, tracked her down, the ex-wife, and said, your ex-husband has passed away. There is a life insurance policy for $1 million. And remember, life insurance benefits are tax-free. So when we say $1 million, it's an actual $1 million, right? It's cold hard cash, basically. He's got a policy worth $1 million, and you're the sole beneficiary on it. So you have 2 choices. You can decline the inheritance, or you can give us your updated contact information. And the way that he loves to tell the story is she responded by, you got a pencil in your hand? Right? Which, how else would she? The point of this is beneficiaries trump the will. And I get pushback from people on that all the time. No, that's not what I put in my will. I don't care what your will says. If the beneficiaries say something different, and in some states, Kentucky is not one of them, Indiana is one of them, you can put beneficiaries on real estate. So this is one of those things that it can get out of hand quickly if you did not build it out correctly.
It's interesting, before I kind of got into this business and learned more about this, it's interesting to learn how unimportant a will is relative to what you think. Because you watch TV, you watch a movie, you get the patriarch of the family passes away, and then everyone gathers around and they read the will. And
reading of the will, I love that.
And they learn, who's going to inherit what and who's going to get what,
and who's not going to get something.
Yeah,
right?
And it 100% never. It doesn't work that way.
Never.
It does not work that way. There's no reading of the will. That's not something that exists. That doesn't happen. And the will, in and of itself, is not important. No. It's who the beneficiaries on the accounts are, and it also is whether or not you have a trust.
And therein
lies
our next level.
Gets you to level 2. So there's your...
what a great transition.
Yeah, there's your transition.
So remember, level 1 is just going to give direction. It just gets your assets to the right place. So a will and proper beneficiary titling is how that works. Okay, level 2 is it's going to add a couple things. You still get where assets go, but now you get control and you get probate avoidance, right? So remember, with a will or with lack of a will, you still got to go to probate, right? Creditors have to have, legally, they have to have the opportunity to make a claim on your estate. That's what probate is. When you get into level 2, you get a type, and we'll talk about this in a little bit. You get a type of trust. Now, a trust is, for lack of a better word, a living entity. In this particular case, it's definitely what we call a living trust. A trust avoids probate, and it does this because the trust owns assets, and unlike the person that we're talking about, the trust doesn't die, right? So when you get control and probate avoidance, here's how you do that. You create a trust. In this case, it is called a revocable living trust. Revocable meaning the person who created it, the grantor, can change their minds. They can revoke it. And living meaning when it was created, they were a living person. That's what that's referring to. So in the case of a revocable living trust, level 2, you are either going to have the trust own the asset now, or the trust becomes the beneficiary of the asset. Okay. Notice I didn't say anything about protection. And this is where a lot of people start making the mistakes. I've got a trust, therefore my assets are protected. No, that's probably not true. Most trusts, the vast majority of them, fall under the revocable living trust category. That's what we both have.
95% plus.
Yeah, probably at least that much. There is no protection here. So, for example, I don't own effectively anything, personal items, right? My home, our property, my portion of this business, my cars, everything is owned by my trust. My wife and I own the trust, okay? But if somebody were to sue us for some reason, all of those assets are on the table. There's no protection here, right? What it does is when my wife and I when we both pass away, our trust owns everything or is the beneficiary of everything, right? So in the case of IRAs, for example, you don't put those in a trust, right? But the trust is the beneficiary of them. So now I don't have to worry about probate on those things because probate is for people that have passed away. The trust didn't die. Mm-hmm. It's still very much doing its job.
Well, really, right? The trust kicks in.
Well, it doesn't have any real oomph until this point. That's exactly right. So now everything in the trust, it avoids probate because the trust didn't die, but it gives me control because the rules of the trust cannot be violated by law after I pass away. Now, I can change the rules on the trust while I'm still living because it's a revocable trust. So I can change the rules anytime I want. But after my wife and I are gone, you can't do that. So you can put some things in there. For example, some of the more common ones. I do not want my children, and let's just say hypothetically, if your children were minors, if you've got them down as a beneficiary or you mention them in the will, they inherit when they turn 18. By law, there are 2 states, I believe, that's not the case, and they're both 19, right? So pretty much, you don't have to be that old to inherit. Well, how many of us were good with money when we were 18?
I didn't know
I don't
what money
see a
was.
lot of people raising their hands in this room.
I didn't have any of it. I didn't know what it was.
But okay, if all you have is a will, if all you have is beneficiary designations, when they turn 18, they're going to inherit, right? And there's nothing anybody can do to stop that. Legally, there's nothing they can do. They can spend that any way they want to, make any mistake. With a trust, the most common thing that you see people put in, even in the most boilerplate of trusts, is my kids are only going to have access to the assets, the money that's inside the trust, when they reach a certain age. They're allowed a certain percentage. And you might see at age 25, they get 25%. And at age 30, they get 50% of whatever's left. And at age 35, they get the rest. There's a million ways you could do this. But that's the basic kind of control. One of the other big ones is if my child has an addiction to drugs, alcohol, gambling, it could be any number of things. You could really be kind of creative with this. They have to have been clean of that addiction for a certain period of time before they're allowed to take any money out, right? You can really be as creative with this as you want to be. It's just where you got to talk to the estate attorney and make it clear what you want. My wife and I, for example, we have 2 sons. They are both 18 or over. So if we were to pass away today without a trust, they get the whole thing immediately, right? I think we've done a pretty good job with our kids, but I'm not going to test that by handing them everything. And they know this. So in our trust, there is a stipulation that says if they are capable of working and they refuse to do so, so we're not talking about disabilities or anything. If they're capable of working and they choose not to work, they get nothing. I don't want them to be lazy. I can't stand that concept. So Kathy and I are gone. They're going, you know what? I'm just going to live on mom and dad's money. My trustee's going to go, no, you're not. And legally, they can't.
Yeah.
Right? And that's control. And I love to tell clients, when I'm playing golf with Jesus, my kids still get nothing if they choose to not be productive members of society. So that's what you do with level 2. It's all about control. So how important is control to you? That kind of dictates where you should be in this.
The term control from the grave.
Yeah. Oh, good phrase. Yeah.
I mean, that's where it comes from. So being able to control your assets even while you're no longer here, that's the whole point of a trust. So a couple things to note on what you just said. So the trust does nothing during your lifetime.
Not really at all.
So many times, you'll talk to folks around, this is why you do estate planning, but the trust only exists on paper while you're still here. At least for a revocable trust, right? It doesn't do anything. It doesn't kick in. There's no job for it to do until you and or your spouse have passed away. That's when the trust kicks in. Okay,
right.
Then it becomes a different animal, and that's when it starts to do its job. But during your lifetime, it just exists. It does nothing.
I would argue it might be as much of a hassle as anything else. So when here in Kentucky, real estate, right? So
that's the big example. Yeah.
My wife and I, a few years ago, we sold our house and we bought what we plan on being our forever home. We kind of downsized a little bit. We bought some land to go with it. We moved even further out in the country. This is our place. Kathy says, I want to be buried in those woods out there behind the house, right? Jokingly. When we did that, as a trustee, I had to sell my old house, right? I did not sign for that. I, as a trustee, signed for that. There was an extra piece of paper involved.
Yeah.
Closing attorney did all that. Quite frankly, most people wouldn't even realize they're doing it. I was told, write the abbreviation TTEE on that line next to your signature because I was signing as trustee. When I bought the house, I bought it as a trustee because it was the trust that was buying it. If you look it up on the PVA website, you will see that our trust owns it, not us as an individual. other than that,
I say that a lot to I say that a lot to clients, especially as it relates to real estate. Like if you look in Business First and you look in the back of Business First, it has like the top real estate transactions for the week or for the month or something. Especially the higher dollar transactions, you can see that usually it's a trust that's either buying or selling the property. Yeah. So it's actually very, very common. It's a very common thing. But yeah.
That goes back to the point that you were making a minute ago about the will reading that you see in movies. Higher net worth people,
this is all laid
out. Will readings, right? It's all done by the trust.
And it's all laid out in the trust. And usually for the most part, people already know what's going to happen. They've already had the discussions. And
great point. So this is one that I think a lot of people really, this is where they start screwing up estate plans. My kids are 18 and 20 as of the day we record this. My kids have seen my will, or excuse me, not my will, my trust. They've seen the entire estate plan. They've read the paragraph that says, if you choose not to work, you ain't getting anything, right? They know where I keep hard copies of this. They know who my estate attorney is, and they know how to contact her, right? So we've had these discussions, even though they're young, right? There are other families out there who have done this kind of thing, but they haven't told the people who are going to be what we call a beneficiary of the trust. They haven't told them anything, right? And I think this is very, very prevalent among baby boomers and silent generation people because they were taught you don't share this stuff with your kids.
Money's a taboo subject.
Money's a taboo subject, yeah. And it's like you are really kind of setting them up for failure because they're going to find out all of the sudden. And by the way, if you have a good close-knit family, they're going to find out while they're in grief, right? Because they just lost a parent or maybe both at the same time. Please, please, please share this information with your adult children.
Well, you alluded to children fighting. Yeah. Family infighting. A lot of that is a result of not knowing ahead of time what was going to happen.
Right. Good point.
Life is all about expectations, estate planning or not, right? Life is all about expectations. If you're expecting something and it happens, you are happy. If you are not expecting something and it happens, good or bad, right? Your mood is determined upon whether that's a positive or a negative thing that you were not expecting to happen. So if you're not expecting to be included in a trust or some type of an account as an inheritance, then you're not going to be disappointed when it actually happens and you don't receive anything. If you are expecting to receive an inheritance and you don't, you're going to be very, very disappointed. You're going to be very, very upset, and you're probably going to take it out on those closest to you or maybe even be resentful, right? Life is all about expectations. So that's why it's very, very important to communicate whatever you and or your spouse want to have happen when you pass away. It's very important to communicate that with your kids or your beneficiaries or whoever the next kind of generation is. So open lines of communication, we do that in our office as well. We're happy to facilitate some of those.
Absolutely. Well, we try. Some people are still a little hard-headed about it.
But we do have those,
For the most part, with the clients that we work with, they are very open to having these discussions with their adult children. We're not talking about your little kids. That's different. We're talking about adult children who are mature enough to handle complex financial subjects. Please discuss this with them. I am always amazed at when we do get our older clients and we have meetings with their adult children and they say, hey, I would like to leave this money behind for you. And the kids are going, we don't want your money. We want you to go enjoy it. The whole point is that the conversation happens, right? And by the way, if you're going to be leaving money behind, it should be invested differently than if you were planning on using it, right? So you need to get your adult children involved in this conversation. So
another thing I'll add too, just real quick. Notice one thing you have not talked about.
Okay.
Is taxes.
Oh, hallelujah.
Trusts.
Go with it.
Trusts are not a tax strategy.
Nope.
I think a lot of people think that, implementing trusts in your portfolio is some type of a tax strategy to avoid paying the man, paying Uncle Sam. No.
Doesn't work that way.
Doesn't work that way. That's not what trusts do. Trusts are not designed, at least specifically as it relates to revocable trusts. They're not designed as a tax play.
That's right.
That they're designed for protection. They're designed for guidance, control, right?
Think about it this way. When you file your taxes, so just Joe average person out there, when you file your taxes, you have to put a tax identification number on your tax return, right? Otherwise known as a Social Security number.
There you go.
When you create a revocable trust, and I'm speaking specifically based on Kentucky law, so there might be a state out there where it's different. And obviously in different countries, if you were listening to this, the rules could be different. But here, the tax identification number of the trust is the Social Security number of the grantor, the person who created it. And the way that I've typically seen them written, if it's a married couple, it can be either him or her. Doesn't matter, right? So if you're filing your taxes and your tax identification number is your Social Security number, but your Social Security number is also the tax ID of the trust, what's that tell you? That tells you that it passes through. Any taxes that are created by monies that are owned by that trust passes right through to the individual. This is not a tax play in any way. Please don't think it is.
And that's a very, very common misconception that, I'm going to utilize a trust to avoid tax issues after I pass away.
No, you're not.
It doesn't help at all.
You can try, but it's not
the tax issues are 100% completely determined by the type of account that an asset is owned in, whether it's pre-tax, post-tax, taxable, right? The way that asset is treated from a tax perspective for your beneficiaries or for the people who inherit your account, completely dependent upon the type of account that it's in. And we've talked a lot about the different types of accounts before.
Okay. For sake of time and for overwhelming people, let's move on to level 3. Level 3 is where we get into what we call an irrevocable trust, right? Now, full disclosure, when the grantors of a trust are deceased, the trust automatically is an irrevocable trust, but that's not what we're talking about here. What we're talking about is you by yourself, or maybe you and your spouse, create an irrevocable living trust, meaning you're alive when you do it, and you put assets into it, called funding a trust. The purpose of this is everything that we've talked about up to this point, but adding one wrinkle to it, and that wrinkle is now the potential for protection is there. I like to phrase it this way. This is not legally the correct words, but I like to phrase it like this because people get this. When we talked about the revocable trust, the level 2 estate plan, you still own the trust. The trust owns all your stuff, but you own the trust, right? When you get to an irrevocable trust, it's not really works that way, right? You don't own the trust, right? Because you as a grantor, remember all trusts have 3 parties. They have grantor, that's the person or persons who decide to create the trust, and they put assets into it. The second person would be the trustee, which is the person or persons who run it. That could be the grantors. It could be somebody else. And the beneficiaries, that's the person or persons who are going to benefit from those assets. With a revocable living trust, that level 2, while you're alive, those 3 parties are all the same person or married couple. With an irrevocable trust, the rules change, okay? So the grantor is the same, right? It's typically a married couple. That's typically who wants to do these. But the trustee is not the same person. Now, they can, depending on state law, the grantor can be a co-trustee, but they are not allowed to make decisions unilaterally. There has to be somebody that is not a grantor that has to sign off on every decision. Mm-hmm. Typically, the trustee and the grantor are not the same person at all, right? Now, this can be a corporate trustee, meaning you hire somebody to do it. It can be personal, meaning it could be an adult child or a close friend, whatever.
Depends on the purpose of the irrevocable
Everybody's
trust.
a little bit different.
Yeah.
And then the beneficiaries cannot be directly the grantors. And that's the key thing here, because the reason why you would do level 3 trust planning, which is an irrevocable trust, is to protect your assets. And you can protect your assets from a lot of things. But the big one is Medicaid. That's what most people are doing this for. There's a lot of other things you can do. I've talked to people who are trying to protect farmland. I've talked to people who are trying to protect assets from the grantor's poor behavior. There's a million ways you can do this, but probably 99% is they are trying to protect their assets from Medicaid spend down. So this is where you get into phrases like Medicaid planning or medical planning or elder care planning. They all are effectively the same thing. You're using an irrevocable trust to own your assets so that if the time comes that you end up in a long-term care situation, your assets cannot be taken in order to pay for that. That's really the gist of what you're trying to do here. This is a very, very complex thing. I could talk for 2-3 hours and not even scratch the surface on this, so I won't go too in depth into it, but the main concept here is the irrevocable trust protects. Now, it does have to be inside of the trust for 5 years. Not the trust has to exist for 5 years, but the asset has to be inside of that trust for 5 years in order for it to be protected. If you're curious about that, give us a call and we'll walk you through it. But the idea is all of the assets are in there, and now you become, in effect, poor, and you become eligible for Medicaid, so that you could go into a nursing home situation. You could file for Medicaid, but not lose your house, not lose your assets, all those other things. It's far more complex than what I'm talking about. But that's the main gist of this, is level 3 is all about protection of the assets that you've got from things while you're alive.
Yes, very much so. The analogy that I always use is whenever you do an irrevocable trust, charitable remainder trust are another reason you might do that to give money to charity. There's other ways to do that too, but for whatever reason that you're utilizing an irrevocable trust, what you are doing is you are basically, for all intents and purposes, you are creating a new person. You are creating a new taxpayer, and you are giving money to that taxpayer. Okay? You are removing money from your own personal estate, okay? And you're giving it to someone else. The money is no longer in your estate. You no longer have control over that asset. That's the whole idea.
That's what level 3 planning is.
That is the intention. The reason you do that to protect, to protect assets in order to qualify for Medicaid funding is a big one. Avoiding estate taxes is another big one. When you kind of get, this is for kind of,
and that depends on the state that you're in. So
yeah, but that you're generally talking about much wealthier people at this point. But to avoid estate taxes for your beneficiaries, you typically would try to remove assets from your estate to get your estate down to a lower, more manageable level, so your beneficiaries don't have to pay a death tax, so to speak, right? But for whatever the reason, at the end of the day, whenever you use an irrevocable trust, you are removing assets from your estate that you no longer own, that you no longer control. There is a tax ID number. That tax ID number is not your Social Security number. It has its own tax ID. That trust will pay its own taxes based upon whatever.
Once again, depending on the state that you're in, there's a couple that are different.
But that trust will pay its own taxes. It's also worth noting this is usually not a tax play because the tax rates are very, very compressed on trusts.
They tend to be higher.
So in order to hit the highest tax bracket, you don't have to make that much money within the trust, right? So this is definitely not a tax play. This is very much a control. Yeah. This is very much a protection.
It's a protection play.
It's a protection play, right?
So without going way down the weeds, because this is a long subject, I want to kind of start summarizing a few things. So when we talk about level 1, level 2, level 3, it's all about what you're trying to accomplish. 1 is direction, the only thing you're interested in, or is control what you're interested in, or is protection what you're interested in. Each level does everything of the one below it. I would add to that, it doesn't matter which level you're on, there's other documents. We talked about estate planning is not just for when you die. When you talk about powers of attorney, there are healthcare powers of attorney, commonly called healthcare directives in today's lexicon. That's where you get HIPAA approvals and all kinds of stuff like that. There are financial or durable powers of attorney. So these are people that have the ability to make decisions on your behalf while you're still living. All of that is going to be part of an estate plan. And the typical estate attorney is going to do all of the underlying documents. So, for example, if you do a revocable living trust, that level 2, they are also going to do a new will or wills for a married couple as part of it. And they typically call them a pour-over will. So it's designed to capture anything that you might have failed to fund in there. But I say all that to lead to this. When you're creating an estate plan, you really need to talk to somebody who knows what they're talking about here. You need to, especially if we're starting to talk about that level 3 type. I typically don't have this conversation with my clients until they're in their 60s before we even discuss it. And they're usually in their mid-70s before we start implementing it.
Yeah, I was going to say,
right?
70s.
I start educating them about this in their 60s so that when we get into, mid-70s or so, because remember that 5-year window, that's, you say it all the time, give me one variable and I'll make a perfect plan, and that's, the variable is date of death.
No.
Typically when you are dealing with trusts, depending on what level of control you want, you need to be working with an attorney that specializes in estate work. When you start dealing with irrevocable trusts, you have to be working with an attorney who, this is what they do, right?
Yeah.
I have seen these get screwed up by attorneys who had the best of intentions, and they did exactly the opposite of what it was designed to do. And I use the example, we've talked about this one before, with physicians. When somebody says they're a doctor, the first word out of your mouth, what kind of doctor, right? If you have a bum knee, you don't go see an oncologist. Might be the smartest person you'll ever meet, but that's not what they do. If you've got, a broken leg, you don't go to your internist, right? Mm-hmm. They're all physicians, but it's not the discipline you want. When you are dealing with trusts, especially the complex ones and the irrevocable trusts, you need to get an attorney who specializes in this field. Otherwise, high likelihood of a mistake.
Very much so. And just to illustrate, just this morning, I had a conversation with a client, and they started talking about trusts, and they said, well, I think we need to do a trust. We prepaid our funeral services. Mm-hmm. We've, been kind of going through some of the planning process, and we talked about some of this stuff before already, but they said, okay, we're ready to take the next step, and, we need to do, they kept saying I think we need to do a trust. And I said, why? Not that they were wrong.
Great question, by the way.
Not that they were wrong, but I wanted them to explain to me what it was that they wanted to accomplish. Mm-hmm. So, they kind of answered. At first they were taken aback. They were like, well, I thought I was told I had to have a trust. And I was like, well, tell me why you need one.
What are you trying to accomplish, right?
What kind of trust, And so anyway, we fleshed that out, and we kind of walked through the steps and talked through, okay, this is why you do level 2. This is why you do level 3, based upon what you're telling me that you think that you need, and based upon what I think that you need, we probably need level 2. And so we set an appointment. They're actually going to be coming back in a couple of weeks, and we're going to go through that process, and we're going to set it all up for them. But this is a real conversation that we have with clients around getting their estate plans set up, and we do this all the time. And these are real conversations that we have.
It's part of financial planning. If you don't have a financial plan if you don't have an estate plan. It is part of it. You have an incomplete plan if this part has not been done. And I am always amazed at the people who say they haven't got it done. Why not? Well, and you get that hem and haw thing.
Time, money.
Okay. Yeah. No, the real answer, I would say, for the vast majority of them is, I don't want to deal with it. I don't want to talk about this. I agree. I don't want to talk about it either. It's the reason we don't want to do this podcast. We're talking about dying. This is not fun. But imagine it's no different than any other thing in life that you have to do, but you don't want to do. Get it over with. Deal with it. Go through the process. Now all you've got to do is check on it from time to time, to make sure that nothing has changed. That's really it.
It's funny because I try to make it as light of a subject as I possibly can.
Yeah.
So, like when the clients this morning were telling me about their prepaid funeral services, I'm like, so where am I going to go see you? Where do I go visit you? Where are you going to be at? Where are you going to end up at? And I try to talk about it like that, say, hey, where am I bringing your flowers, et cetera, right? Just because I try to make light of it and get them talking about it. It's going to happen to all of us, and, we're all going to do it. So, we might as well try to make it as fun of a topic as we possibly can, and
you do your best,
and at least go into it, with as much optimism and hope that we are preparing the next generation to be prepared upon the receipt of all of the assets that they are set to inherit as part of this overall great wealth transfer that we are currently in the midst of experiencing and will be experiencing really for the next couple of decades as all of the baby boomers pass away.
Well, let's keep in mind when we talk about the baby boomers, and I'll wrap it up with this. The baby boomers are 1946 to 1964, if I remember correctly, which means it's 2026. The oldest baby boomers, they turn 80 this year. Statistically, you've already beaten some of the odds.
Yeah.
The youngest baby boomers, a lot of them are still working, right? They're 20 years younger. They're still in their mid 60s. They still got a long way to go. So this is going to be going on for quite some time, to your point. If you do not have a good, complete estate plan, you don't have a complete financial plan. I think is the way I would sum that up.
So that is a good place to wrap up, and let's
talk about bourbon.
Talk some bourbon.
And the first thing that I want to talk about is the fact that this is scraping the back of my throat to the point that I'm losing my voice.
It's not the most pleasant pour we've had. I wouldn't say it's bad, but I would never buy it.
Okay. I think this is awesome.
Yeah,
which is
it's okay.
I love the point. You're going, it's okay, and I'm going, this is fantastic. That's what bourbon's all about. There's the reason where there's a lot of them. I would akin this to spicy food. Some people don't like spicy food. Some people like spicy food for the point of spicy food. Yeah. But me, I love spicy food, but only if it's bringing flavor. The face that I made was not, oh my gosh, this is so hot, I'm going to die.
No, it's not that.
There was a flavor that hit me like a ton of bricks, and it only hit me on the first taste. It was on the back end of it, there was a mouthful of dark chocolate. I only got it on the very first hit, so that was probably because I didn't have any other flavors in my mouth. All right, that went away. And then I got really dark cherry and maybe some other berries on top of the normal caramel flavors, the normal bourbon flavors. That's what Old Forester's known for, is they're not complex. This is really good. I would suggest putting a couple drops of water in it.
It definitely mellowed out, and I enjoyed the taste. Not that it was bad before, but I enjoyed the taste and the experience a lot more after like 2 drops. It's hot. It's hot.
I'm thoroughly enjoying this. This is awesome. Kind of like when I have Mexican food that is really good. Yeah. But I got water, sweat just running down my forehead. If you really like the spicy stuff.
Get your meat sweats on, yeah.
Ooh, this is kicking. It is just absolutely full of flavor. I love this, but there is no question this is not for everybody. And I will also tell you, the way that Old Forester markets the 117 series this year is no different. They sell it for, I think it's $130 for 2 bottles. The bottles are always done in 375 milliliters, so it's a half of a normal size bottle. So if you think about that, it's a $130 bottle. I did find this particular bottle for half that price. I found it for retail, so I only have the 1 bottle, and I found it at Kroger's. I was just, holy cow, it's sitting up there on the shelf. I don't know that I'm going to like this enough to buy 2 of them, unlike that extra old that we talked about, that one of the best things I've ever tasted. This is not one of the best things I've ever tasted. I'm glad I've only got 1 bottle. It's going to take me a while to finish this one. This is the bottle that I bust out for the guy who likes the really, really hot flavors. This is not for everybody. That being said, I love that, but I could never have more than 1 pour. It is tearing my throat up right now.
It's okay. It's fine.
Fair enough.
Fine is probably. I mean, it's not bad.
Mm-hmm.
And I definitely. It's not tearing my throat up like yours. Clearly, I'm not.
I'm having trouble talking.
I mean, there's a little bit of an aftertaste there, but it's not that bad. I don't know. I just don't find the flavors as probably fun as you do.
This is a great example of to each his own bourbon.
Yeah.
Right.
So
some people are going to love this. Some people are. Yeah, it's okay.
Fine.
There's probably not a lot of middle of the road people, and I think that's probably true with most things that are this high proof.
Well, on a 130 for sure. I mean, 130 is you're gonna. I mean,
you're not going to have a lot of middle of the road people. It's I really like it, or I'm not a big fan. So, you know. So there you go. Let's wrap it up.
Well, we're an hour in, probably a pretty good place to wrap up. So thanks for watching. Thanks for listening. Hope you enjoyed all of our ramblings on estate planning. And if any of them might be relevant to you or anybody that you know, please feel free to go to our website, fwppartners.com, schedule an appointment, give us a call. We would love to chat with you in any level of detail about any of the 3 levels of estate planning that we discussed today. Thanks for listening. Thanks for watching. Until next time.